copyright does not apply to non-humans.
There were some groups like Metallica was suing fans, and so does that happen a lot now?
Post music on, say, your social media posts, that's a different license.
Well, Jack, thanks for coming on the podcast. So you came from
Sure.
Deseret Book to BYU. What were you doing there, and what made you come here?
So I worked at Deseret Book for about a decade, about 9 plus years.
Mm-hmm.
I started as their managing licensing expert and was promoted to the director of business affairs, where I handled all their contracts, all the negotiations, all the paperwork, all the legal
Is
stuff.
that mostly like sales contracts, like supplier things, or
Well,
was it intellectual property?
All of them. Anything that comes through the company that had a contract attached to it that was
Mm-hmm.
more than just a perfunctory purchase order or something like that with a signature on it, I would typically review in detail and provide advice. And sometimes we'd interlineate, we'd draw certain clauses out and write our own in and that kind of thing. But it was all different kinds. It was royalty agreements with authors. It was publication agreements with third-party providers. It was the leases for our spaces in malls.
Deseret Book must get requests from people to use content for all kinds of oddball purposes, right?
That too. Yes, permission requests and granting. And sometimes that was just as informal as an exchange of emails, which would qualify as, hey, that's our consent. Or sometimes it would be, formally papering that up with signatures and an exchange of a licensing fee and everywhere in between.
Okay. And then you came to BYU to the Copyright Licensing Office. Why don't you explain for us what CLO does?
So the Copyright Licensing Office, our mission statement is that we are subject matter experts that are a resource for the campus community. Mm-hmm. What it doesn't say is that, we're here to be enforcement or compliance officers, because the copyright policy at BYU says that people at BYU in the community utilizing creative content are the ones that should expect to make sure that they're using it properly, because they're the ones knowing what they're doing with it. In other words, they make the determination whether a fair use exemption might apply or not. And so it's really up to whoever's using creative materials that they're compliant.
So I could be a professor in class and I'm putting something on like Canvas or whatever learning management system I'm using. I'm like, this seems a little sketchy. Like maybe I'm using entire copyrighted work. So then they would come to you and you would do the clearances or make a judgment call.
We could. We'd rather train people to do that themselves, but we're always around as a resource to provide advice and consultation. And so really our mission is more about training and awareness. It's like, I think the old Librarian of Congress, Daniel Boriston, said this really interesting phrase. He said, education is learning what you didn't even know you didn't know, which means you don't have to know everything, because there's a lot of ins and outs with copyright law. And no one has to know all of it. You just need to know enough to know when to ask the right question. And that's what our office is for, is to help answer questions.
Okay. And so for us, it's professors mostly, but you can imagine entrepreneurs, anyone doing anything online might have times when they think, I'm using someone else's work here. They might own the copyright. What's just a normal person way of approaching those issues? What should you think about? Well,
you should know and be aware of copyright in particular, that just using an attribution doesn't give you permission. That's kind of one of the big issues.
I love it on YouTube when people post.
Don't you?
Say no infringement intended.
I love those ones.
Well, if intent were an element, that'd be important.
Right, and there's no intent is not an element, and so that doesn't matter. What it really says is, I know enough that there's a copyright issue here, but I don't want to really look into it, and that's a problem.
Yeah.
Right.
Yeah. Exactly. So professors are probably largely aware of this sort of issue. But what are the common issues people ask you about?
Oh, so it's a variety. It's all over the map. That's what I love about the job, is that, again, we're trying to just be subject matter experts so no one else has to be. We handle issues like movies, public performances, use of music, creative works, content that's used in classroom, outside of classroom, publicly facing, accessible online. It's all over the map.
And all those things are complicated issues. People might not realize, like if you own a restaurant and you're playing a TV in the corner, there are rules about what you can do, right? Like how many people can you rebroadcast something to?
Yeah.
How do these things work?
Yeah, like public performance licenses in particular. Well, we have those on campus that allows all of our stages to sing, perform music that's already owned and copyrighted and expecting royalties from. I think one of the biggest issues that we see is people using music not on campus, not under those licenses, not under the public performance licenses that we've already paid for at BYU. When you post music on, say, your social media posts, that's a different license. That's one of the things that we're trying to raise the flag on, to say, be careful using music when it's accessible to the public.
Okay, so you could do a performance in a concert hall on campus, and we already have the licenses set up for that.
Yes.
But that doesn't mean that you can then put it on Instagram and everywhere else.
Yeah, different type of license.
Back in the day, I remember when Napster was first out, there were some groups like Metallica was suing fans and people like that. Do you remember?
Uh-huh.
And so does that happen a lot now, or do companies just realize this is going to happen and we're just going to do takedown?
Do you know, it happens more now.
Really?
Yeah. Because the music industry is sophisticated enough that there's machinery behind the scenes to chase after those kinds of requests and fees and license issues. And what I mean by more so is that if you're online, it's more findable than ever before, especially when you've got web crawlers that are automated now with AI engines that are able to identify content. Like YouTube behind the scenes has their content ID algorithms that they know whose picture that is, or whose music that is, or whose video that is. And a lot of times those will be automated responses sent to that particular account saying, hey, that's someone else's, did you get permission?
Yeah.
And that sometimes may be overkill, because there's lots of exemptions to getting permission. Fair use is a good example. So I would say, yeah, it's something that is becoming more policed rather than less.
Oh, that's super interesting.
In one way, yeah.
Okay, yeah, and I have thought with AI, maybe it's possible to have perfect copyright performance where you have these AI tools out there, compliance, finding all the infringement that happens. But I have noticed, how good are those tools at finding things that are modified a little bit? Because sometimes on LinkedIn, it's supposed to have a tag if you have AI-generated content, but sometimes I resize something just so it fits and looks better, and then that's gone. Like, it's no longer flagged as AI. I would rather people know when I'm using AI, but how good are those tools?
Well, it's like you say, if there's permutations, derivatives, adjustments, edits, then it's not as good. There was just a case, a few months back, where the person said, hey, you used I think it was an image, you used my content, and it didn't have the attribution that I had put on it. And so removal of the copyright management information is kind of a separate issue. But the court said, if the use has edits or modifications or changes, then you don't need to particularly use the content management information because you've made a derivative. And so that's a difficult question to answer. How far down the line of edits do you get before it becomes a derivative work? It's hard to tell. My best advice is just always, use attribution, because even if you don't need it for legal copyright purposes, it's nice to know where the source is. It gives credit to the creator. But again, back to our original conversation, that using the attribution doesn't grant permission.
Yeah,
it's just a courtesy.
Well, and people at a university are probably really good at attribution because they're thinking in publication mode. It's like, even if I have the right to use this from a copyright perspective, I don't want to plagiarize someone else's work. So
yes, and the distinction between plagiarism for academic scholarly work versus copyright, there's a little. It's kind of like a Venn diagram. They overlap, but they're different in some ways. Where if you're doing scholarly research and you're using someone else's studies or work, that may not be copyrightable. You can't copyright facts, for instance. Or math, for instance, or simple charts or graphs. But if it's someone else's work, you'd still want to attribute that you got it from them just to name your source. That's more of an academic ethical responsibility that we all want to follow, even if it may not be something that's strictly required for copyright infringement purposes. So they're similar but not the same. Copyright infringement, slightly different than plagiarism. And plagiarism is where you lean heavier on attribution. And that's a great habit to be in, because nothing wrong with attributing as well for copyright.
Yeah. Okay, and so to help people understand these issues, you have the copyright certification program at BYU.
Yeah.
What's that, and what was the idea?
So it's a self-help, online, self-guided series of little video snippets with information provided, and just little quick quizzes to make sure that you've caught the idea. It's something that we promote pretty heavily because it's kind of the first wave of what we call generating first responders across the campus. People that know enough about copyright that they know what to apply or even where to ask. Right. So it's something they can do themselves. We've divided it into 5 different categories of expertise, like one's specially made for faculty, whereas one's made for librarians and museum curators. Another one is made for media specialists, licensing specialists, administrative gatekeepers.
Do any of them focus on students, or are these all for employees?
Students do use them as well. And typically they're more interested in the media specialist ones because there's a lot about posting on social, that kind of thing. So and
when will social media posts result in litigation or action from a copyright holder? Because most of the time, how damaged are you if someone posts a piece of your work on social media?
It's a great question. It's a great question. So often, depending on how you use something and how much of the thing you're using, it may be a fair use where you don't need permission. That's an open question because none of us know what fair use is until a judge decides what it is.
And to be fair, my copyright professor used to always say, and she was a Disney attorney, she was fantastic, and she would always say, that you don't want to be in a position where you have to argue fair use in court because at that point you've already admitted that you've infringed. Now we're just talking about whether a defense applies.
Yeah.
So not a great place to be, but you could end up there.
You could. And it's an affirmative defense, which means you have to, provide that information after the fact. And so even if you're right, even if it is fair use, you've still gone through the whole heartache and the hassle of, getting there to prove that.
Yeah.
So there's kind of 2 different ways of looking at when you're trying to use someone's creative copyrighted expression. You think in the strict terms, is this allowed?
Yeah.
Does the law provide an exemption for this, or do I need to license it? That's a great question to ask. And then the broader question is, am I gonna get an issue in terms of having to deal with paperwork and communication and having to explain myself and defend myself? So there's sort of 2 levels of am I formally compliant versus is this just something I don't want to touch?
And strategically on the corporate side, if you're a business and you think someone's infringing your work, you have to make a strategic judgment. If big guy sues little guy, how's that going to look? What is the PR?
Yeah, right. All of that. Well, and just the hassle of it all. But that said, part of our educational effort on campus is to empower people to know what exemptions they do have under the law and what they can do in utilizing creative content, especially on campus for academic purposes, for sure.
Okay. Well, great. Well, Jack, we got to get to my pet issue here,
which
is the generative AI
love it.
litigation and legislation efforts. Where are we at? What are the cutting edge issues right now?
Okay, so for right now, what we're pretty certain of, because we're tracking 23 different cases currently with AI and how they're scraping data and using it to train on. What we know for sure, at least for now, and legislation is percolating through and could change in the future, but currently, copyright does not apply to non-humans.
Right.
So you have to be a human to own copyright in the first place.
Or to be infringed, right?
Right.
Yeah.
Yeah. And so that protection is only available to human authors. Well, generative content that's being produced by LLM is not created by a human because there's that black box in between the generated prompt, engineered, structured input, and the output. There's just kind of too much unknown right now to say that was generated by the human who's writing the prompt.
You know why that's
so it's not copyrightable.
Yeah, I follow the logic, and that's probably the right answer, right? But I don't think it's being applied in other domains. Like if I used an LLM to create something illegal, like bomb instructions or something, and post it like that, I don't think in court I could say, well, that wasn't me. That was the LLM doing that.
See, yeah, and because someone's driving it, right?
Yes.
Yeah, and so it's an open issue. They're looking at it now. They're deciding, which way this is going to go. And just last week, 2 judges in the same building, 2 floors down from one another in Northern District of California, had a little bit different perspectives on the 2 different cases that they were hearing at about the same time, just days from each other. And one of them was more concerned about what's the impact on the incentive to create, which is the whole heart of the copyright law. I mean, the Constitution provides that provision, like it's for the useful arts and sciences. It's for progress.
And I always say with patents, because that's there too, inventors are in the Constitution,
Yep.
that the trade-off is you're going to publish your information in a patent so that society can use it, in return for which you get this monopolistic ownership for a little while,
Yes.
for 20 years.
Yes.
And so I kind of think the same thing applies to authors. But one thing that seems weird about our system is it says that these rights are secured. This is in the Constitution. The rights are secured for a limited period of time to authors.
Yep.
But the actual term of copyright is like life plus 70 years.
Yes.
That is not limited to me. If I create something, that's pretty unlimited if it goes beyond my
It
life.
used to be on parity with patent. It
Yeah.
started at 14 years, and then they doubled that to 28, and then they doubled that, and then and all the legislatures. And well, I mean, one of our biggest exports from our country is entertainment.
Yeah.
And so Hollywood has a big lobby with Congress and says, hey, this is content that we do need to protect in terms of the industry.
Yeah.
Right. But this is what I love about you and I is that we both shared the exact same clause under the Constitution for
Yeah.
patent and for copyright. I think it's Article 1, Section 8, Clause 8.
Yeah, one of the few substantive
It's
legal
both.
positions in the Constitution.
Yeah. Yeah. It's writings and discoveries.
Yeah, that's right. And so Gary Vaynerchuk was saying this last week that he's really really optimistic about the future of IP ownership. He says companies like, I don't know, Warner Brothers, Disney, whoever owns Universal, whoever owns IP,
Sure.
there are going to be huge opportunities going forward because of all these AI things. Like I did a post on LinkedIn a while ago about we should in a few years be able to like custom generate an alternate ending to a movie or something like that. But it'll only be possible if we get all the rights from the rights holder. So anyway, there could be new commercial opportunities. So these things are really valuable.
Yeah.
to those.
Well, and so the other case in the Northern District of California that I was comparing earlier,
Yeah.
the other perspective was, is the playing field being inundated by so much AI generated content that it's a disincentive, that there's less
Interesting.
desire or impetus for human authors to create something when it's just buried in a sea of
you can never compete.
similar content.
Well, do you remember a few years ago, there was someone, it was a copyright project, it was a nonprofit group, and they were auto-generating text. They were trying to create every string of text possible. And there was this issue of, does that mean they own the copyright to all of it? Or does that mean that nothing's copyrightable now?
It sounds like a Borges novel, doesn't it? Infinite number of typewriters with infinite monkeys typing, and can you own all of that?
Yeah.
It's crazy. In fact, I think there's a popular music band right now that is completely AI, and most of the fans don't even know that.
Yeah, I saw that online. That's right.
It's wild.
There'll be more and more of that.
Yeah.
So I had my first thing, I think I was telling you last week, I did a LinkedIn post about the Tesla Robotaxi rollout. And just to illustrate it, I used a clip that I created with Google Veo,
Right.
which has gotten so good. And so this was the first time where people widely saw the video clip and seemed to think it was real. To me, it was obviously fake because I generated it. But people posted comments like, why isn't she wearing a seatbelt? And I had to respond, because she's not real. But it's just going to be more and more of that coming.
Do you know, and that's why even if you didn't need to put an attribution under generated AI stuff, because no one owns it, because AI doesn't own copyright, it's still, in my view, it's still really good practice because it says that. It says what the source is.
Yeah, you can never do it enough, though. I posted it so many places on that post that this
And
is
still,
AI generated,
sure.
and people would still say,
Yeah.
why
Yeah.
is she wearing a seatbelt?
Yeah. No, it's really important to use not only attribution, but the right licensed version of the software. For instance, on campus, we have paid versions, I think, of a couple of the big AI engines.
Yeah, that's right.
And the benefit of going through a paid subscribed license version of it is that you get the indemnification provision that says, hey, if there does happen to be some copyright issue arise that's from your use of the licensed product, it's the product owner that will take the responsibility for those copyright issues. Yeah. That's a nice protection. That's a nice layer of willingness to accept responsibility on the part of the AI owner rather than the AI user.
Well, and as you'd expect, Microsoft has thought through those issues really well. So on Copilot, it's totally an enterprise setup.
Yeah.
And because of their reach, I have to think they're one of the dominant players in the long term. How could they not be?
Well, they're trying to be, sure.
Yeah.
But there's a lot of competitors. In fact, BYU is looking at almost 20.
Sam Altman says that you should keep AI models proprietary to the company because you don't want them to be easily gamed, and you don't disclose these things. Elon Musk says, no, you should open source all of it so that people know that it's honest, which is what he's done with the first version of Grok.
Yeah.
Which one of them's right?
Great question, right? The answer is depends.
Yeah.
Talking about licenses again, one of the other benefits is that your data is in theory secure when you're using a licensed product, because that's the data that they're guaranteeing under the terms of the subscription that they're not using for training. For instance, if you type in, hey, our members of our office are, they're here are their names and here's their birthdays and here's their personal address and personal phone number. If you type all that in, because you just want to generate like an address directory
Sure.
internally,
Spreadsheet, whatever.
You want to make sure that data, because you've input it as a prompt, doesn't get used to train on and can be found later by someone else just doing a search. Hey, what is the tech transfer department's personnel directory, and it knows that.
Yeah.
Right. And so the benefit of using a licensed version of the software is that in theory they're not using the input data to train on.
Okay, so for personally identifiable data, I'm totally there with you on that. But what about the fact that it's really weird for academics in particular to want to opt out of training data for models? Because shouldn't we want to make the models as accurate as possible? And aren't we doing cutting edge research that should influence its view of reality?
Absolutely. And isn't that the give and take? There's the tension there.
Yeah.
In fact, in Japan, their statutory guidelines for using artificial intelligence essentially say it's mostly not an infringement of copyright to use creative content, copyrighted content to train AI models.
Yeah.
Right? And so it's way less of a concern or issue, maybe not in terms of privacy, but in terms of infringement in Japan. And they've done that intentionally because they want to drive innovation. They want to say, we want as much factual information as we can get. We don't want to have to worry about, editorializing or, picking or choosing or seeing what's not licensed and what is available, that kind of thing. Because then you've got, like a skewed data set, right?
Yeah.
So, and the question is, in the US, where regulation is pretty strong, can we still be competitive when other countries maybe don't have as many guardrails?
Yeah. Well, this is why I think in the long term, Grok does really well as AI, because it's transparent and it's open. It's less, it's supposed to be truthful. It's less focused on editing than other platforms. Like ChatGPT, I use it constantly, but it is so frustrating when you search and say,
and
that inquiry might violate our policy.
Yeah,
I'm like, what policy?
That's right. That's right.
And that's a case of it just being a bit paternalistic, maybe for business reasons. But so I think there's got to be a race to the bottom where the most open platform with the least rules wins, doesn't it?
It seems like that, I mean, that's how music streaming started, is by pirates.
Yeah.
Until the industry caught up and said, look, let's just find a way for all parties involved to have a good compromise. And so, $10 a month to license music is actually a better deal than going to a record store like you used to, with the
better deal for the consumers.
Same about, right? And so we'll get there, I think. And the real question is will it be legislated in such a way that it innovates growth but also protects? There's all kinds of consumer protection issues and privacy issues and that kind of thing as well. So,
well, when I was in law school around 2000, I took a class on technology and the law. It was just very clear to me at that point that the government couldn't keep up with the pace of technological innovation.
Oh, for sure.
Legislation always lags.
Right.
And isn't that 100 times as true today?
Yes.
How can it ever stay on top of AI?
Well,
issues?
and when courts are wrestling with these new questions, they're saying, well, we could maybe try to answer this for the particular matter that's in front of us, but this technology is moving so fast that even our opinion may be useless in 3 years because we'll have moved beyond it so far.
Yeah. Yeah.
So
interesting time, but I love
way
AI
interesting.
Issues. Are there any quirky AI issues? We're all focused on use of content, like training the models and so on. Are there any quirky issues that we're not hearing much about?
Well, we had the Westlaw case where Thomson Reuters has, the key system for Westlaw.
If people don't know, all legal precedent, all cases are organized by this key system. And it's super interesting. There have been studies that have shown the organization of the KeyCite system has actually influenced the evolution of law in some ways. Have you ever seen that?
Yes.
And so,
right.
But it's absolutely dominant in legal research to use the system from Westlaw.
Yeah, and they claim ownership on they're essentially the summaries, 3-sentence summaries of what that case holding is and what it's all about. And the question was, did you create anything new when really you're summarizing
Right.
a judicial opinion, which is public domain and not subject to copyright? And the answer is, well, it's kind of like a painter that created something out of existing material,
Yeah.
which is sort of a weird
So
analogy.
it is protectable. That was upheld.
They held that it was, but it has subject to appeal, and so
Yeah.
and it goes back to your earlier question, which shouldn't the data be more robust and more consistently useful than qualified and excised and carved out,
Yeah.
and say this data set is privately held and owned by a company, and no one chose to license that, and so we don't have the benefit of that. Versus like the Keynote system, well, you could probably get all that information from the case law itself, which is public domain, and create your own summaries. And so why didn't you do that?
Yeah.
So
you raised one question that I've had about copyright, this tension. It just seems to me that if you create something original, the more false your material is, the more likely it is protected by copyright. Because if it's truthful, it might be just a statement, a summary of reality or
how
some
interesting
natural
is
law.
that, right?
And so,
If it's wildly inaccurate, then that's
should be
not a
protected.
fact.
Yeah.
And so it's more creative,
Yeah.
which is subject to the greater protection.
yeah. And similar, like Cory Doctorow pointed out that, the novelist, that that it's more protectable to criticize people than to affirm them. Like if I post about someone saying, "Oh, I really love this book. Here's my favorite passage," I might get sued for that. But if I say I hated this, here's why, then that's protected commentary.
Because it's original.
Yeah,
It's unique. It's not just regurgitating,
yeah. So that's weird. It seems like the incentives might not be exactly what we want. I'm not sure. But let's talk about, while we still have some time, copyright and tech transfer. So I deal with copyright, like mostly you think of tech transfer as licensing out patents, but we license a lot of software. What are some issues we should think about in tech transfer?
In licensing software? Well, I'm thinking of the Oracle Google case, where the court determined that API type of software is ownable. It's copyrightable. It's original expression that someone coded.
The API itself is?
The API is.
Okay.
However, if another company, even a competitor, is using the API for a different purpose from which it was created, for interoperability purposes, or to put something on a different platform, for instance, then even though someone owns that API software, their use and purpose may be so different that it could be a fair use.
Oh, interesting.
Not requiring permission.
And is that, let's think through
Depending
that.
on how
the
transformative
elements
their
of-
use is.
Why don't you go through the elements of fair use for us? And so one deals with the monetary impact. And so I guess what they would
That's
say
right.
is there's no monetary impact because you're in a different industry.
Maybe, yeah, right? And because not directly competing, because you've used an API to put it on a different platform, or for, a completely different, like maybe just to like reverse engineer and discover, how that works or whatever. I don't know if that's a thing in
Yeah,
patent.
that seems pretty competitive.
Right?
Yeah.
So the four elements, there are four factors that the Supreme Court has asked us all to keep in our head and to analyze and to weigh
a balancing
together.
test, yeah.
It's a balancing test. Well, technically it says under, Section 107, including the four factors. So there, I
there could
suppose
be
there
others.
could be others. But the
Okay.
four factors are the nature of the original. And typically that's going to say, has it been published or not? Because if it hasn't been published, there's more of a, incentive to say that should be more closely held to the vest rather than being published.
Got it.
Well, nature is how creative it is. Is it super original like a painting, or is it, just kind of like a math book,
Yeah.
with more factual statements?
Or the phone book would be a classic example.
Phone
right?
book, right?
Yeah.
So the nature is one element. Your purpose is the second one. And for the last couple of decades, the buzzword there has been, is your purpose transformative? And if you've added new message, new meaning to the original creation, so it's utilized in a different context, or presents something of your own genesis, making the thought unique, then it's less likely to be an infringement.
So if I
It's more likely
sample
to be-
someone's song in my new song, is there a possibility I get away with that, or would that always be?
Well, so music is pretty well captured.
narrow,
There's a
okay.
big engine to like identify music, especially just little samples and snippets and short phrases. And so there's been a lot. In other words, there's been a lot of litigation about music,
Yeah,
and
I
so
suppose
there's
so.
a lot of guidelines on music,
Okay.
like kind of like where that range might be. Sampling, I would be wary of that because that's someone's original expression. right? But if you, for instance, use a picture of a guitar player, but you use it in your museum exhibit about guitars, the purpose of the photograph originally was to show the musician, but your purpose as a museum is highly transformative. It's different. It's a different message, because you're not necessarily interested in the performer. You're interested in showcasing that model of guitar in your Museum of Guitar exhibit.
That makes sense. And that passes the common sense test.
Yeah.
When you hear that, it's like, oh, that makes sense.
Yeah.
But then it's, they say hard cases make bad law. And there's some hard cases right now. What if I take that picture of the guitar and then I use Google Veo and I make an animated dancing guitar out of it,
right,
which I then post or sell or something?
So, have you changed the purpose of it? And then you weigh the other two factors that are remaining: the nature, the purpose, the amount.
Yeah, that's
is
right.
the third one. And this is what I'd really like to communicate: is that there is no black letter set threshold for amount.
So to put the point, so if there's a 1,000-page book and I reproduce one page, that seems less egregious than if I reproduce 200 pages.
That's right.
Yeah.
But there is no set amount. A lot of back in 1975, the academic community tried to propose a 10% rule. Say, hey, and the amount of 10% seems reasonable, but the court flatly rejected that. Did not build that into the law. The legislation said that's not going to be something that we're going to measure, because it needs to retain more flexibility than that. When you use a single photograph for a completely different purpose, you still need to use 100% of that creative content. And that could be fair use.
What about parties acting not in concert, but adding up? So what if there are like 5, we'll say 10 different book retailers, and each of them give you a 10% preview of a book, but it's a different 10% for each of them. So you can get the whole book. You just hop from one to one.
Right, yeah.
I mean, there could be that
you've
effect,
noticed
right?
they've pulled that off of Amazon and that kind of
they've
thing.
changed
Where
that.
it used to be handy to try to find that. We look at that also on campus as well, in terms of are you using one chapter this semester and another chapter next semester, kind of
keep it consistent,
kind of things. So we're careful with that for sure. But that's very right. When you start adding up the amount, when does it start to become too much? And then the fourth factor comes into play in the fair use analysis, which is the one you began with, which is the effect on the market.
Yeah.
If you're using a whole bunch of a book, should you probably just have bought that book?
Yeah.
Right. And so the effect on the market, and this is kind of another nuance to remember, is so often people say, I'm not profiting. I'm not making any money. I'm not charging admission. I'm not selling anything based on the creative work that I'm using. But that's not the focus. It's not that you're not making money. It's that the owner, the creator, might be losing money. And the way to analyze that is say, is there an existing licensing mechanism? Can you go online and quickly get a way for $25 to use a movie clip? And the answer might be, there's probably a website for that. And if there's a licensing mechanism, that's typically showing that there's a market, and that if you're using something that market is already providing, that's part of what you have to weigh in your 4-element analysis.
Another weird aspect of that is that often if you infringe, like if I show a little clip, like just the other day on Twitter, someone had posted this clip of some movie, I forget what movie, and I saw it and I thought, oh, maybe I'll watch that one.
Yep.
So like it was probably an infringing use, but a few people like me probably went and bought the movie. So that actually probably helped them make money.
There you go. So that's the question of, am I helping promote their product?
Yeah.
That's not part of copyright law, but it's part of reality. And so often when we seek out licensing permission from content owners, so often they'll say, we're flattered, we're delighted. We're glad, we're so happy you're even interested. We'd love for you to use it. Right? And so that answer could be most of the time the right answer. The difference is you're not the one that gets to make that answer. To give that answer. It's the copyright owner. So if you say, hey, I'm putting a movie clip up, I think it's promotional, surely the copyright owner is going to love that. You might be right. You're probably mostly right, but it's still not your decision to make. Right?
I had one time I self-published a book, and the someone did steal it, and so now it was on sale at all these sites that I had not published to.
Oh no!
So I sent a few takedown notices, and no one actually took them down. It was really weird. It's I think people respond really well to traditional publishers, but if you're like a solo creator, it could be rough.
Do you know? And so back to that initial thing.
Yeah.
Is it helping to promote? Is it giving you a bigger audience? Is it giving you, essentially what a publisher might be doing, which is marketing for you?
Yeah.
So there's kind of the strictures of copyright compliance versus the real world of, hey, the copyright owner may really appreciate your use as a fan.
That's true. Yeah.
But it's
How
hard to
hard is
say.
it-
You don't know because you're not the copyright owner.
How hard is it to get a hold of someone like with the copyright owner? Maybe they do support what I do, but how likely are they to respond to my request that I sent?
Yeah, so there's kind of two levels, if that. One is if you're really serious as an author, for instance, or a movie maker or a photographer, you'll register your creative content with the U.S. Copyright Office and potentially even other copyright offices in other countries. And one of the reasons to do that is because then you're on the list. And so if you, a fan, are looking for who is the owner so that I can formally ask permission, one of the easiest places to look would be the U.S. Copyright Registry because they'll be listed. Their name is the author or composer or creator and the title of the content.
Yeah.
That's kind of the first level. The second level is they'll usually put it in if it's a book. They'll usually put it in the book. If it's a video, they'll usually put credits at the end. So they'll self-identify.
Yeah.
Point there is that if they've already put content, creative content information that has to do with copyright, you'll want to keep that, preserve that, because they've put it there, and it's actually a separate offense to take that off.
Okay.
Right? We talked about that earlier about whether,
Yeah.
unless it's a derivative, then it just becomes more yours than theirs, that kind of a thing.
Yeah.
Yeah.
Okay. Interesting.
It's tough, a lot of moving parts, right?
Yeah. Yeah.
That's the fun part of copyright, and also what requires expertise in copyright is because every copyright owner is different and may have a different feeling for when they appreciate people being fans and using their stuff, versus when they want to keep it locked down because it's theirs and theirs alone.
But it is a property right. We consider it a type of property, right?
Yeah.
And so copyright's interesting because it touches us all. So like so many of our areas of law, everyone kind of feels like they understand it.
Yeah.
But no, it's extremely complex, and you really got to get into it, right?
That's why with that earlier quote, education is learning what you really didn't know you didn't know.
Yeah.
And so that's our mission, is just to be subject matter experts, to at least give people enough to say, oh gosh, I should probably ask.
Yeah.
Perfect.
All right. Well, hey, thanks so much, Jack. It's been really interesting.
Hey, glad to be with you. I'm a big fan of Tech Transfer. I
right.
was just noticing that you guys are going up in the charts. I think BYU had a promotional piece just last week that said you're fourth in the nation in terms of tech transfer.
There was a study relatively recently
That's amazing.
that said that. Yeah.
I
Thanks.
just think that's really cool.
We have people.
You guys are doing amazing work.
Thanks. Love it. I love what we do. And we have faculty that are world class. They could be anywhere. They choose to be at BYU, and then
Yeah,
just great
nice.
entrepreneurial students. So good.
Super cool.
Thanks, Jack.
Yep. Thanks, Dave.